Welcome to Women Winning Divorce. I am your host, Heather Quick. I am an attorney, entrepreneur, author, and founder of Florida Women's Law Group, the only divorce firm for women by women. I love thinking big, thinking outside the box, creating creative solutions for women, and empowering women to win in all aspects of their life. Our approach at Florida Women's Law Group is to provide women with a strategy to not only achieve their objectives, but win at life. I believe that what may show up as adversity is simply an opportunity to change and improve your life. In each episode, I sit down with innovative professionals and leaders who are focused on how you can be your best self before, during, and after divorce. In these conversations, we are looking at how women can win at life. I have the unique opportunity to meet women when they are at a transition period of life. But that is only the beginning to becoming your best self and winning at life on your terms. With our guests, we enjoy the opportunity to explore ways all women can win and enhance their life, no matter where they are in their journey. Because divorce is just a point in life, not the end and not what defines you, rather a catalyst for your growth. Welcome to this week's episode of Women Winning Divorce. I'm Heather Quick, owner and attorney of Florida Women's Law Group. Today, I'm being joined by Banda Nadeau. She's an attorney and owner of Nadeau Family Law. And she has worked in many different legal areas like civil defense and criminal defense, but ultimately is passionate about family law. And of course, we had the great pleasure of working with Banda at Florida Women's Law Group many years ago. All right, Banda, so today we're talking about mediation. So tell our listeners a little bit about why you love mediation so much that you became a mediator.
Well, mediation is a type of confidential alternative dispute resolution that allows parties, with the help of a mediator, to resolve their family law disputes without having a judge decide it for them. In mediation, parties can get creative when coming up with marital settlement agreements that a lot of times won't happen if they go before a judge.
And, this week we're talking about mediation because one thing I think, Banda, that many, at least in my experience, many people don't know is that mediation's required, right? If you're going through a divorce, you gotta go, don't you?
You do. In Florida, you must in good faith attempt a mediation before going to court. It is court ordered to attend, but parties need to understand that it's also a voluntary process. So when you attend mediation, you should never feel pressured during mediation to settle. And again, although it's court ordered, the courts encourage parties to try and resolve their marital issues at mediation as opposed to a contentious courtroom situation, which a lot of times does happen, unfortunately.
It does. I've learned even more so really this year because I've had the pleasure of interviewing attorneys all over the country, and not every state requires mediation in a divorce. Very few actually. So it has to be, everybody has to agree. And that's been an interesting perspective when I've talked to lawyers in other states. So actually, I think Florida is a bit progressive in this area where, it's required in particularly, divorce cases. And why do you think that the courts do that? What do you think is the intent behind requiring mediation?
I believe that couples started out as a family. A lot of times they have children and emotions are very high. People want to fight, but the courts hear this day in and day out, and they know that the parties want to be heard. But in the same vein, the courts can only do so much and have to follow the law. And although they probably would like to be creative, they can't. And usually when parties go to trial, especially if there's children, they will get a standard parenting plan, and it's nothing like they could do if they went to mediation, and where they have control and they can fashion it to their liking.
Yeah, and I think, I love what you just said about that the judges know that the parties want to be heard. I don't know if they always remember that, but I know we as attorneys do, and you
I know I've been in situations where I said to my client, if I've heard this once, I've heard this 1,000 times. Well, wait till the judge hears blah 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 blah. And it's hard because we are dealing with clients who say, well, that may or may not come up in your opportunity to share with the judge in the way you think isn't going to really be that way. And then he may dismiss that, or she may dismiss that because it might not be relevant to the issues, even though it's very relevant to the individual.
And parties also need to understand, especially if it's a long-term marriage, you have a certain window of time and you can't get out everything you want to tell the judge. And like you said, a lot of that is not relevant. The judges, although, they might want to entertain and listen to it, they just don't have the time. They're on time constraints, so they can't. And so you have to focus on what is the most important. That's why mediation is nice, because a good mediator will listen to the parties. They'll let them talk. They'll let them understand that they realize the situation they're in. They want to be empathetic, but they are getting to be heard. It's just not the judge hearing it, but they do get to express themselves in mediation.
And I think that's so very important. And I'm certain. I mean, does that has to come into your mediation training, right? About providing this space for the client to somewhat vent, because you're the neutral person listening, right? I mean, as their attorney, I've heard it all. They know I'm on their side, but they want to express it to somebody else. Right? I mean, does that come into your training? I would think it does.
It does, absolutely. Of course, you have to explain to them and reiterate that you're a neutral third party and you're a problem solver, and you are there to listen to their side, understand what they're going through, assess the situation. And a lot of times, mediators, I know I do, I will let them know I may be a devil's advocate, but I'm only trying to show you a different perspective or what may happen here as opposed to going to court. So it's
Well, and I think it's there's an art to it. I have found the better mediators have that a higher level of emotional intelligence to be able to read the scene. I only get to be in one room. I'm not a mediator, but I would always wish, or not really wish, like I want to be there for 2 hours, but I'd rather probably let my imagination run. But you gotta. There's just a lot of skill in effective mediators to allow to go into the room, with the wife, her attorney, let her feel heard, understood, but also communicate your role. And then you got to go to the other side and make sure the husband, their attorney, they feel heard, they understand the process, and that how you're going to navigate, between those two. I do. I think it's a great process. And I think it works like 95% of the time. Sometimes, hey, sometimes not the first time, not the second time, maybe the third time's a charm. We can get into that, like how many times you have to mediate a case. But well, tell us a little bit for our listeners to know, because you're an attorney and also a mediator. So how does that happen? How do you become a mediator?
So for me, I've been through a divorce, and I I was bitter. I wanted to fight. And I think the older I got, the more I realized, and after being in trial, seeing what can happen, I just started to try to branch away from heavy litigation. And I decided to become a mediator. So, what an individual has to do is they take a 40-hour class. It used to be, when I trained, it was for a week, but I now have seen options where they will break it up into weekends, because a lot of people just can't devote an entire week to mediation training.
Yeah.
And also, after you complete your hours, then you actually mentor with a certified mediator, and you observe some, and then you also actually conduct some under the supervision of the mediator. And then once you've accomplished that, then you receive a certificate from the Florida Supreme Court, and you're officially certified as a mediator.
And now, as of now, in what you did, you have to first be a lawyer to become a mediator in the state of Florida. Is that still currently correct? Like, if you wanted now to be one?
No, actually, any there are mediators that come from so many different professions. I have seen, actually, when I was in training, there were pastors, teachers, counselors, and I think sometimes they bring a different perspective to a mediation than just an attorney would. They see things differently. They've never been in court. I know sometimes attorneys who are also mediators, it's hard for them to switch that hat from
Right.
being an attorney to a mediator. But if it's something you're passionate about and you want to really try to solve the conflict before they go to court, then I totally would rather do this than anything else.
Yeah. Well, and I mean, and that's amazing because I can't imagine being a mediator for anything. And so, but that's the whole point, right? Because we all are called to it, and we need people who are mediators. And I'm going to be biased because I'm an attorney and I have a high regard, of course, for the law, and think that a mediator who also understands the law and who is a lawyer, to me, would be better. That's just my opinion, but you don't have to say that. I think that is a way, especially for divorce. I mean, you got to know the law, understand it, and also, don't you think, have a familiarity with the players, so to speak, as far as who are the judges that you may be in front of. Knowing the lawyers involved, kind of, it just is going to give you that insight that otherwise you wouldn't have, and I think that insight can help you settle a case.
I agree, absolutely. If it was me, I would highly advise somebody to attend mediation with an attorney. Mediators can't give legal advice, but they can explain the statutes. They can draft a concise mediation agreement that's not going to fall apart later on. The mediators keep up with the current laws that somebody else is not going to be able to, but if you're an attorney, you're always going to keep up with the updates, and that can be detrimental to two parties if there's somebody that's mediating that isn't keeping track of the updates, and that could be detrimental to somebody's case. So I'm with you on that. I agree. I would much rather mediate with an attorney.
Absolutely. And I think that, now let's talk a little bit about the process because it is in Florida. I mean, you can go without a court order, but typically, we have a court order. We're going to talk later about like collaboration and mediation, but typically, there is a requirement, right? You've got to put in 2 hours. Is it varied on the judge as far as they're going to say, hey, you got to at least give it 2 to 4 hours as a minimum before you say I'm not going to agree.
Right. A minimum four.
And because it's just, takes some time for each side to get in there and begin that process. And ideally, at the end of mediation, you have an agreement, right?
Not like you said, practically 95% of the time. And if a mediator is patient and persistent and keeps the parties on track and controls the situation as well. So, you have to circle back around people that are emotional to get them back into the mindset of, look, we're here to resolve this. And so you can move forward with your life and not spend lots of money trying to litigate and trying to get on the court's docket. So, and a lot of times, like you had mentioned, it may take more than one session. And every mediation is different. So it really depends on the parties, the issues, if there's children, as to how long the process might take.
I completely agree. We're going to talk a little bit more, and I think I want to talk also about, what happens in a mediation in general terms, when we come back, because that's what I think a lot of people don't know. What are they, although, I mean, we got to admit the good TV shows are court cases, right? They're not showing an exciting mediation, right? We're litigating and arguing, and there's a jury. It's just way more exciting on TV and movies. So not anybody really has probably the framework for what does this look like, right? Are we all stuck in a room and have to fight it out, right? But that's not the way it is. So
no. Things have changed a little. Pre-COVID, everybody would attend mediation in person. And back in that day, parties would sometimes all get together at first so the mediator could give a statement. And sometimes parties would all stay together, but that's very, very rare. Most of the time, the mediator will give their opening statement to everybody and then send them off to their own rooms. And the mediator will go back and forth. Now, almost all mediators will conduct a virtual mediation if the parties want, or they will meet them in person. But the mediator will put the attorney and their party in one room and then the other parties in the other room and basically go back and forth between their virtual rooms. And it's a lot of people prefer that because it's more convenient. A lot of people would rather be there in person. And I think that depends on the mediator's preference too. Sometimes you can judge more body language when you're in person as opposed to in a virtual environment.
Yeah, I think we can talk about that more. I've been surprised at the effectiveness of doing virtual ones, but I do think there's Zoom fatigue. A lot of us are over it, and many times there's not that connection that sometimes really does help because if as we know with our clients, if they feel like they've been heard, then now they can go on. It's like sometimes they're stuck in I got to be heard before they can get to now I can start making decisions. And so sometimes I think in person there's that opportunity to feel a connection with the mediator and that, okay, I've been heard. Even though half the stuff I said, my lawyer told me not to say, like it doesn't matter, but I needed to say it. And this person heard me. Now we can go on and, work through the process. But we'll get into that a little bit more. We'll talk more in depth. We're going to take a quick break. And for our listeners, please take a moment to subscribe to our podcast as well as review it if you liked it so far. That will help more folks find us. And we are available on most major podcast platforms like Spotify, Apple, Google, and iHeartRadio. We'll be right back. Welcome back, listeners. Again, I am joined today by Banda Nadeau, a family law attorney and mediator right here in Northeast Florida. And we've been talking about mediation. And why that's important is because in a divorce and a family, and I'll get into that a little bit more because it's not just your original divorce. Mediation is just required in Florida when you are litigating on pretty much everything, unless it's, cases with injunction. Or an injunction case. That's not clarify that. But right, Banda, I mean, pretty much the court, you can mediate any family law issue, and the majority of them, the court's going to send you there to mediate anyway.
Yes. But before you can, I know when you're wanting to schedule it for trial, one of the first things the judge will ask, have you attended mediation? If not, okay, I'm going to submit an order. I encourage you to attend mediation first and try to work out your issues before coming back to me.
Yeah, now that's nice because the judge says, I encourage you. No, he's ordering you, listeners.
Right.
Don't think that you can be like, well, he encouraged me, but I don't want to go. No. You'll end up in court with a fine and all kinds of stuff you don't want to have happen if you just think that was a suggestion. But what they are suggesting is we really want you to come to an agreement so that you don't have to come here and basically have a stranger decide the outcome of your money and your family, right?
Correct. Absolutely.
And, but part of that I was saying is like, so, this is women winning divorce. We're talking about divorce and family law issues. But you can, a lot of times when we've talked about it on the podcast, you go back to court. You have, you want to modify an agreement. You want to change something, whether it's the money or time sharing with the children. You will have to go to mediation for that, won't you?
Correct. It's not just for initial divorces. It's for any type of modification as well.
And so I think it's good to understand that you're gonna have to go. And the way I've always looked at it from, from the lawyer's perspective with our clients is, listen, we have got to go. And you are gonna be paying me, your attorney, you're gonna be paying the mediator. So let's make the most out of it. And let's go in with an open mind and really try to settle this case, because it will be in your best interest. It will be a long day many times. But it's generally, I would say, if you can have input into this final agreement, that's a win for you. And you're done, and you have closure. You can have some closure.
Yeah, exactly.
Okay, let's talk about the time frame, because we said you have to stay for a minimum of 4 hours. So what's your longest mediation?
I've had one go into 2 in the morning. It has happened, and it's a long day, but you have to keep I will say, it's one of the situations where it depends on the party. Some people want to stay in mediation because they're afraid that once they may be so close, but then there's a couple of issues that they're just haggling over. And sometimes everybody's afraid to leave, because if they leave, although the parties aren't supposed to tell others what was discussed in mediation, they do. And everything, that 12 hours may just fall apart. So a lot of times you just have to stick in there if you think there's a possible way that this might get resolved. So, and that's when a mediator needs to be patient. I know back in the day they would provide food, snacks, which you don't get in virtual mediations, but
it's really recognizing that sometimes you get so close, and then it's part of the process, just continuing to work through as long as you can. I've had different cases. I know I did a 16-hour one. Definitely went way into the early morning of the next day, but sometimes we've also done 2, because I think it's valid, and I want our listeners to hear that. Like, if your attorney says we might need more than 1 day, and you're thinking that's a lot of time, but it's very emotional, right, Banda? I mean, because you're talking about your life, your property, the relationship, and it can be exhausting for people, and they might need to go rest, come back the next day without feeling like, hey, anybody walked away. We didn't lose any ground. We just rested, and now we're here, and we can maybe finish up, because it's really unrealistic for us to be signing an agreement at 2 a.m. We might feel pressure.
Not thinking straight, and just a situation where one party is just, I'm ready to be done. I don't care. Just give it to me. Let me sign it. And then that's where issues come up later on. So it's, like I said,
the finality of when you have the document, because ideally at the end of mediation, if an agreement is reached, then a document will be signed by everybody before they leave.
Right.
And that document is going to be binding. So that's why it's so important. And that's why, I've had cases where I've had to tell my client, and the mediator, I can't let her sign it right now. Like, I just don't, I feel like it's just it's now like the end of something. It seems too emotional. And I think that, I've got to let her go home, and we can, maybe sign it tomorrow, but it's just, she's not in a right spot. And I mean, don't you agree? I'm sure you would say that too, Banda, if you saw this.
Yes, absolutely. I mean, you want to protect your client, you want to protect their rights, but you want them to feel comfortable and safe, and know that this closure is going to be positive and they've done the right thing, as opposed to just halfway going through it, not really paying attention because they're exhausted, they're emotional, and then if they sign it, and then they regret it.
Exactly. Well, and that's the biggest thing, because there's not a lot you can do once you've signed it, and to sign it out of frustration or exhaustion, or just like, I got to get out of here, are not the right reasons. And I think that any any really good mediator, of course, would say you should, and not pressure and encourage the other party to like let this agreement stand for 24 hours. Give them that time because you don't want issues afterward. Not everybody will do that. They'll say, hey, we're either doing it today or all bets are off. I mean, and as we know, that can have a feeling.
Yeah.
It
Yeah.
can, but I've been in situations and attorneys, they recognize that and they are like, yeah, okay, we'll give you 24 hours. Like this isn't on the table for a week, but you know what? If you get it signed by tomorrow, then we can all, have an agreement. And I think that that's not something that I did 15 years ago. That wasn't like what we did, but now it's just been more often that you recognize that and think, you know what, I don't think it's good to sign right now, even though we don't want to back out of this. There's a lot of good things about the deal, but the emotions are running high, and the client just might not feel as though they are really doing this voluntarily.
Yes. And it's just a situation, when we're attorneys, we know our clients and we can gauge them and know, okay, I'm confident that all this client needs is some rest and time to regroup, and it's not going to fall apart. And we're doing our clients a favor and advocating in their best interest to let them have a pause and a good night's sleep and then come back refreshed. And
absolutely. And sometimes that those aren't always the norm, but they do happen. And, I think it's like you said, knowing, your client as far as that, and then the mediator recognizing that as well, that, hey, like this was a lot for us as attorneys, we're used to being in court and just like time kind of just doesn't factor in. So it goes so fast, you don't realize the time. Because we have at least for me, and same with mediation, all of a sudden you're like, oh my goodness, so late. We need to take a break so that you can really absorb what we're doing. Because sometimes at the end, we work through an agreement after hours and hours and hours over many issues. And now you have to sit there and read a 25-page document. That's a lot of lawyer language, for clients. And, it can be that in and of itself is overwhelming, because now they're like, oh my gosh, talk about this. I don't remember. That was at 10 a.m. and now it's 8.
right.
And I think as mediators, just recognizing where people are and are they really absorbing all of this as we're going through.
Yes, and keep reiterating, do you understand? Are you comfortable with this? And have you gone through this with your attorney? And do you understand what you're doing? And then a good mediator will say, do you need more time? And not rush the clients.
Now, okay, you mentioned in the beginning, which it's really important, the neutrality, right? Because you are the neutral third party. And how do you control that? Like, how do you maintain that when you're mediating a case? I mean, has it ever been difficult, or you wonder if one side is, questioning it?
I know when you first start out in an opening statement, a mediator will, one of the first things, I am a neutral third party. I am not advocating for you. I'm not advocating for your spouse. I am here to help you both come up with the best possible resolution. You're both going to have to give and take. Nobody is going to walk out of here a complete winner. It's negotiation.
Mm-hmm.
But you have to, because you have to keep reiterating the neutrality. If you're in with one party for a long time, the other party is sitting over there going, their mediator spending so much time with my spouse.
Mm-hmm.
I know they're on their side. And so when you finish with that party, you have to go into the other side, explain, listen, I know I was there for a while. I'm going to spend the same amount of time with you. You're going to be heard as well. And just reiterate to them that, again, this is neutral, but I have to listen to everything on this side. And now I want to hear your side. And so we can try to come up with a resolution.
And, I would bet, well, and I don't know this, but I'll ask you because, again, I'm not a mediator. When you're mediating, because it's going to be different, I would imagine, if you're the mediator and the husband and wife each have an attorney versus they're in there and they're not represented. Because I would imagine, because you would hope and know that, hey, their attorneys advise them of some of this. Plus, they've got somebody to talk to when you're in the other room as well, versus worrying, that maybe you're siding with the other side. But like, I guess it's even harder because I'm sure you mediate for folks that aren't represented as well.
Yes, yes. And mediators have to be extremely cautious when you have two pro se parties, meaning they're not represented by an attorney, because you can't give them legal advice. However, you explain the statutes to them, you explain what factors, elements a judge looks to when they're making decisions. And again, it's a delicate line when you're with pro se parties as opposed to attorneys.
And, and I tell people that, that's a question. Well, we're just going to go to mediation as if like, we're just going to go to the park, like,
Right.
No, it's not like, I'm just going to go. It's a big deal. And if you sign something, like you're going to be bound to it. And my thing is, do you even know if it's a good deal or not? Because I tell them like the mediator, they cannot advise you on, and give you legal advice. They can say, this is the law. This is the deal. This is your situation. You have a choice. And so I think that there's a misconception for a lot of folks that, oh, well, we're just going to go to mediation. Like, and that's going to be fine, which it's great. Mediation is an amazing, amazing process, especially in divorce, because it can really bring so much of the animosity down, right? It can eventually, maybe not that day, but I think long term, a successful mediation can help alleviate just that look back of negative emotions that do sometimes arise when there's a trial, because the whole thing's adversarial, right?
Yes. Yes.
But I think that's just sometimes individuals don't understand. They're like, well, you're a lawyer. Like, what do you think? You do this? Should I do this? I mean, that's where I'm sure your neutrality factor and really sticking to that is challenging, because not everybody who's not a lawyer, they don't always really understand why you can't.
And it is frustrating. I mean, it is frustrating to maintain neutrality sometimes when one party is being unrealistic, but you have to just reiterate and stress the law to them and tell them, I understand what you're feeling. I understand your position. However, this is the law. And
right. Those conversations are never easy, regardless. But in your situation of mediation, I know that it is. We're going to take another short break, and we'll be right back. And during that time, listeners, please take a moment to check us out on social media, Florida Women's Law on Instagram, and Florida Women's Law Group on LinkedIn, YouTube, and Facebook. Also, check out our podcast, and please leave us a review so that others can find our podcast. Welcome back, listeners. Banda and I are here today discussing mediation in the divorce process. And we're going to broaden it a little bit. And if you missed the first two segments, please go back and listen, because we tried to really, frame out what mediation is, what it looks like in a family law divorce situation. But there's something else that is been around for a while called collaborative law. And I know that Banda specializes in collaborative divorce and has been trained and, it's a lot of experience in that. So I'm going to ask her to let our listeners know, what is collaborative law and what is that process?
So in the collaborative process, each party still has an attorney. The attorneys are collaboratively trained in addition to attending mediation training as part of their collaboration training. But in a collaborative process, it is more of a team effort. So it's not only collaborative attorneys, but other professionals involved. And rather than parties being in separate rooms and a mediator going back and forth, they try to all get together as a team to discuss the issues. There may be an instance, say, for example, one of the team members can be a neutral facilitator, which is usually a social worker, a counselor, and they will assist the parties with developing a parenting plan when there's children involved. If one of the parties is highly emotional, as opposed to paying their attorney to be their counselor, they can pay this neutral facilitator a lot less to get out these emotions, go through the process without, let the attorney focus on the legal aspects. The neutral facilitator will focus on the parenting plan, the emotional aspects. If there are a lot of assets, businesses, a lot of times there's a financial neutral who is also part of the team, who will prepare the financial affidavits, analyze the both parties' financial situation, and then suggest alternatives for how to distribute their assets and liabilities. But after, it's confidential, and sometimes it saves money. It just depends on the issues. It depends on if there's children involved, but it's just another alternative way as opposed to mediation, where you're not deciding everything in one day. You're taking it step by step and scheduling different meetings. And it just depends on the parties. How quick do you want to get through this process? How many issues do you have?
So I think that there's going to be there is a level of acceptance. I think that the divorce is happening, and that I trust you enough that with these professionals, we're going to work through this, because, and that's me speaking from from my perspective, because many times I feel I've seen what can increase the adversarial nature of a divorce is the lack of trust in the documents, in anything that they see or issue, anything the husband says, and hey, rightfully so, that's been broken. I think that would be just a bigger leap in a collaborative process if there was already such a distrust of your spouse, because even though they're professionals there, like they're going to verify stuff, right? The collaborative process, it's not like you have to wholeheartedly just rely on your spouse, because there's a lot of professionals involved that are going to verify the information, right?
But you have to be committed. And you touched on a very good point. Number one, they both have to be committed to the process. Number two, they both have to have trust. When a parties enter into a collaborative agreement, they commit to being forthcoming, being transparent. And if one spouse thinks the other spouse is hiding assets, it's going to be a problem. And even though they will commit and say, all right, if there is something that one spouse knows the other spouse has, but the other spouse isn't providing it, then the neutral financial can subpoena the records. But if you're having to go that far, then the trust is lacking. So it's hard to draw everybody back in when one party is not fully committed and wants to be transparent. So it's not for everybody. Mm-hmm. It's a great process, but
well, I think it's not for everybody, but it is for, and I think it's it's taken off maybe more popular in different areas of the country, even different areas of the state. But I find and I think anyone who hears this says, oh wow, there's going to be attorneys, a financial person, and a counselor, for the mental health stuff for the kids. Wow, doesn't that sound like the right way to go through divorce? But as we know, many clients may believe that, but think we just aren't going to be able to do that together. But I think also what, to me, is the biggest selling point, other than just a nicer, happier way to go through the process, is the privacy, right? If you really feel like, hey, if you are a celebrity or if you are, more of a public figure, this process can give you privacy that the regular divorce process cannot, correct?
Correct.
And that, to me, is the buy-in that, both people have to want it, right? But recognizing, hey, if this person has a public image or something that this kind of knowledge might hurt and affect financially, okay, that does affect both parties. We have at least that common interest to make this work so that this stays private.
Yes, yes. And one more thing about the collaborative process that parties need to understand is parties can enter into the collaborative agreement right off the top. Parties can file a petition, have the other party serve, and then they can decide, okay, we're going to tell the judge we would like a motion to stay, and we're going to enter into the collaborative process. But the parties also, they need to understand that once they enter into the process, they need to stay committed, because if one party decides to drop out of the process, the collaborative attorneys have to disengage. Then they have to start the whole process over. But that's another reason why you have to be fully committed, because you don't want to have to go through this twice.
Right. And I guess, and that goes into there has to be a level of trust in I do think it starts with your spouse, because it's like, all right, he or she is not doing this for some underhanded reason. And then, that is because ideally this collaborative is an open process. Both attorneys have had open conversations, not only with their client, but with the other client, right? So that's why that says if somebody drops out, now all these people who are working together, they can't work on this anymore, because it was done in a very open, collaborative way, right? Where we are all getting together, and now you have this attorney-client privilege, like you have to start over, because otherwise there's all these privileges and you have a certain right to keep some things private.
Correct.
Well, and and I can see, I guess that's why, in order to be, a collaborative attorney, you had to become certified as a mediator to really understand that type of process, mediating and coming to an agreement and working through to compromise.
Yes, and you have to be committed to the process, just like you're going to advocate for your client. But at the same time, as opposed to the attorneys trying to pit the parties against each other, they're both working together to find a solution that's going to benefit the parties going forward. And again, especially if there's children involved, it's just so beneficial to have that neutral facilitator to guide them through a parenting plan. And again, if there's high emotions involved, to work with them through that.
Yeah, I agree. I do think that, more and more that I interview various people, and whether it's attorneys or those in the mental health field, that, in regards to the parenting plan, I think it would be helpful, just even regular divorces, that, bringing in somebody from that mental health side to work with the parties on a parenting plan, because, they have children together and they may not like each other anymore, but they gotta work on the parenting plan. And, I'm not saying we do a bad job as attorneys working through, but, we have that training by default and experience, not by a degree. And I mean, as long as I've been doing this, at the end of the day, I always tell my clients, I'm thinking of how to help you and get an advantage legally, or legally, how this all comes into play, because that's the way I'm wired. That's our job. Versus, just like you said earlier on, somebody with that mental health background, they just have a different perspective to offer you. And that can be very helpful to see something from that perspective, particularly as it relates to parenting your children.
Yeah, and every family is different. So there's not one size fits all parenting plan. And parties just need to understand that there's this fourth judicial circuit guidelines right now. Of course, things may be changing. We don't know yet, but um, judges typically, I've just seen it over and over again. Even though you can explain the situations of the parties, sometimes it just comes out, okay, it's a 60-40, here it is, and then the parties are stuck with it. Where if they have a neutral facilitator, or even like again in mediation, they have somebody to listen, to understand their time constraints, their schedules, what's best for the children. And especially, as you know, in family law, it's always the best interest of the child. So,
well, and Banda, I loved it when you said that, and then you did come around to the guidelines, because you're like, there's not one size fits all parenting plan, but however, there is. If you go to the judge, there is, right? And that's what you get. And it used to be, back when I started practicing family law, every other weekend, a dinner night, right? And now it's every other weekend, Thursday to Sunday, and one overnight during the week. So, listeners, you're getting the one size fits all parenting plan if you're just going to end up in front of a judge, versus having the opportunity to really, customize, because your family's different, and for whatever needs, reasons, you should take that time to have a plan that works for your family, because not every, and in the one size fits all, it doesn't take into account family traditions, different holidays other than your traditional school schedule, and things that could really matter to you. And if they're not in that parenting plan, oh, you're going to be back in court and back in court and back in mediation, and wonder this second time, why didn't we do it this way the first time? I could go on and on about that, and Amanda's heard me say that before, so she knows why. And usually it comes down to not being advised properly, and not having an advocate who, one, doing it yourself, get done right, or just get done quick. Or not having an advocate who really understands your goals, and then you're just stuck with this thing, and there it is. Or it could be due to your inability to compromise on anything, and then you ended up in front of a judge and you got a one size fits all, and you didn't really see how that long-term impact would be, which is kind of, we've seen it before, because they come to us with it and we're like, yeah, that's rough, it's going to be really, really hard to change.
yes, and you only wanted to go through this once.
Indeed, right. Well, Banda, this has been such a pleasure discussing mediation with you. I really appreciate your time today, and I know our listeners have enjoyed it as well.
Well, again, thank you for having me. It was a pleasure seeing you, and thank you.
Well, I've got one more question, though.
Sure.
This is a question I ask all of my guests. So before we go, can you impart on our listeners what you've learned about divorce and family law, throughout the years in your career, that would be a benefit to the women listening to our.
Absolutely. So I've been divorced myself, and I've been on the opposite side of the desk. I know what these women feel, every emotion, every bitterness, the fear, everything that goes along with it. I think that's why I've always been drawn to family law. That was my favorite class in law school. And after going through what I went through with my attorney, I just wanted to make it a better process. And I would never want my clients to wait weeks without a phone call or an email from their attorney. And so I would always try to respond to everybody every day if I could. I know, like I said earlier, I was bitter when I got my divorce and wanted to fight. But now, as I've gotten older, I see the importance of taking a step back and realizing this life will go on, things will get better, and don't try to put your emotions aside, stay strong, get through this so you can move on and have a better life. And I don't know how many clients I have had that have reached back out to me that are happy, they've moved on, when I know, and you know too, they've sat across from our desk and thought their life was over, but it's not.
It's not. It's just really just a new beginning, a new chapter.
It is. It is.
Well, thank you so much again. We have reached the end of our show, and we're so thankful to Banda as our guest this week. You can find more out about Banda at www.nadeaufamilylaw.com. Look in the show notes for the link to her website as well. And if you or someone you know is going through a divorce or thinking about a divorce, of course, reach out to us at Florida Women's Law Group or join our Facebook group, Women Winning Divorce. The links for both resources will be in the episode description. And if you enjoyed this episode, please subscribe and leave us a 5-star review. Thank you for listening.
Thank you for joining me for this episode of Women Winning Divorce. My goal is to elevate your life and the way you are thinking so that you are best equipped to win at life. If you enjoy the show, please subscribe so you automatically get my new shows every week. And I would love to hear from you personally. Come join the conversation on social and join our Facebook group, Women Winning Divorce. We welcome your comments and suggestions. We want to bring you content that helps move your life forward. Women Winning Divorce is the place for an elevated conversation on how women can thrive during times of adversity in order to live their best life.